Good afternoon, everyone, and thank you, Kathy, for keeping this technology moving week in and week out. So thanks again. So we're here again this last Tuesday of unofficial summer. Next week we'll be here the day after Labor Day, gearing into fall. So today we have one quick announcement before we get into the agenda. I wanted to share that we have a breakfast briefing planned for the fall, dealing with the pregnant worker, what to expect when an employee is expecting, a clever title. And we will be across New York State in 13 different locations. So I hope everyone here, at least those who are in New York, can find a location close to you. These will be in person. They will not be available via webinar format. So come join us in person. Hear a deep dive on this issue. There have been a number of legal developments involving pregnant workers over the past year, or maybe 2 years. We've touched on many of them here on this webinar, but this will bring it all together for you. Just before this, I was just chatting and I volunteered to do the Binghamton location. So if you want to see me in person, I'll be in Binghamton. And so we're really looking forward to that. We always enjoy the in-person events from our labor department to you. So next, let me introduce today's agenda. We have three presenters, so we may finish a little early, although a couple of these might take a little bit longer, a little deeper dive. First, we have Kevin Cope out of our Buffalo office. Kevin's been here a couple of times talking about the same subject, non-compete ban developments, because there has been quite a bit of litigation around the FTC's non-compete ban. So he's going to give us the latest. That'll be a quick update. Then we're going to go to our Rochester office, our associate there, Travis Tallarico. We'll talk about something that I thought would be timely for this season. We're heading into the fall. We're heading into a presidential election year. Passions might be high around that topic in many workplaces, and we want to give you some guidance of what to do when dealing with political speech in the workplace. What are the guardrails? What can you limit or not limit in the workplace if your employees want to start talking about the election? And then finally, Laura Harshbarger, the chair of our Labor and Employment Department, happy to have her here today, is going to give us an update. If you recall, about a year ago, I don't know, I don't think anyone missed it, a landmark Supreme Court decision dealing with diversity, equity, inclusion programs focused on higher ed. As we expected, there's been litigation since then, starting to define the outside contours of that topic. And so I invited Laura here today to give us an update. It's been a little over a year. What's been going on? Have there been any interesting, useful, informative cases? And what are the best practices these days? Not just in higher ed, but even more broadly than that. Hopefully, we'll have some questions and have a good discussion with Laura. So with that, let's get started with Kevin with the latest on non-compete. I should say the non-compete ban. Thanks for coming back, Kevin.
Thanks, Kristen. Thanks for having me. So for everyone, good afternoon. And this should be a relatively brief update because there's been a flurry of activity around the FTC's proposed ban on non-compete agreements. And recently, the court in the Ryan LLC versus FTC matter issued a memorandum and an opinion that struck down the ban. So essentially, that is not going to go into effect on September 4th as planned. The ban is of no effect at the current time. And essentially what the court found there was that the FTC under the Federal Trade Commission Act did not have the authority to make substantive rules such as the non-compete ban. They're allowed to protect individuals against anti-competitive activity, but they're not allowed to make a wide swapping rule such as the proposed non-compete ban. In addition, the FTC found that there was not enough factual support for the ban. And essentially what the FTC did in issuing the ban itself is it supported it with information relating to specific state non-compete bans and specific cases. However, no state in the country has had such a wide sweeping non-compete ban as what the FTC proposed. So the court found that the FTC could not support its non-compete ban with those specific state studies because none of them approached the intensity of the ban itself. And then in addition to the extent that there are individual cases, those rest on the specific facts of the case. In addition, the court found that the FTC was required to basically look at potential alternatives for the non-compete ban, either a softer ban or no ban at all with different kind of rules, and it failed to do so. So ultimately, the court held that the FTC's ban was not statutorily authorized and that it was arbitrary and capricious in that it didn't have any support. So under the FTC didn't have the authority to do what it did, and it struck down the non-compete ban. So, all of our communications to date have been, prepare as if this is going to go into effect. But right now, it is not going into effect. The only way for it to basically have any life is for the FTC to appeal it and for the appellate court to overturn this decision. And here, the FTC has already indicated that it is likely going to appeal the decision to the Fifth Circuit, which is the Court of Appeal that is encompassing the District of Texas that issued this decision. Based upon history, it is likely the Fifth Circuit will affirm that decision so that it will not put the ban back in place, but it will affirm that the ban will not go into place. And likely what this is leading to is a collision course with the Supreme Court, where the Supreme Court is likely going to have to wrestle with this issue of what does the FTC Act actually allow the FTC to do, and is there a factual basis for the FTC's ban? So we will continue to monitor the situation, but as of right now, the ban is not going into place, and it is unlikely that it's going to go back into place in the near future. So if anyone has any questions relating to that, please let me know. But as of right now, there's no need to prepare for the ban because the ban is not going into effect.
Well, that's a great update. I think many of our friends here are breathing a sigh of relief and can put away those letters that they were perhaps preparing to communicate with people who are subject to a ban. So that's great news. Thanks, Kevin.
Thank you.
Great news for employers. So moving on to our next topic, we have Travis, as I mentioned, talking about political speech as we head into our election season this fall. So Travis, take it away.
Thank you very much, Kristen, and hello, everyone. Good to be back on the weekly webinar. As Kristen aptly teed up for me, as we are unfortunately wrapping up summer, and depending on how you view things, unfortunately, you're not approaching election season. That is going to be a very hot button topic in the workplace, and so we felt it would be timely for us to go over a few basic points regarding political speech in the workplace. So we're going to move to the next slide. Thank you. So first, at the outset here, it's important to understand that private employers do not inherently commit a First Amendment violation when disciplining or terminating employees for speech. And the why of that is because the freedom of speech protections under the First Amendment do not extend to private employers. With this being said, that's not to give private employers free rein to freely punish employers for their expressions of speech, political or otherwise, in the workplace, even if the employer is private and the speech does occur in the workplace. We'll be talking about some of these considerations over the next couple of slides here, if we can move on to the next one. So these are our next slide here, our main considerations we want to be taking into account in the event that, we'll say probably the likely event that political speech does arise in the workplace between employees over the next several months. So the terms of any employment contract or employee handbook, to that latter point of employee handbook, if there is anything in any policy that's in place regarding speech in the workplace, which we will get to a few points on any such policy in a couple of minutes, whether the speech could possibly be considered protected concerted activity under the NLRA, any New York labor law protections relating to political speech, whether the discipline would be considered retaliation for protected activity or a violation of public policy, or any prior discipline or lack of prior discipline that could give rise to a discrimination claim under Title VII or either of the New York State human rights laws, the general law for the state or New York cities. To that last bullet there, it's good to be keeping in mind when we're looking at this issue of what else is going on in the context of that political speech. So for example, for the last bullet here, any prior discipline or lack of prior discipline that could give rise to a discrimination claim, you'd want to be careful of looking to, for example, a situation where a employee was disciplined for something they said in relation to making political speech, where the employee could then push back and say, well, no, that's just a guise for discriminatory activity because of my participation in another sort of protected class. So context here is important. Next slide, please. So focusing on a little bit of the National Labor Relations Act here. So we want to make sure that any policy that does limit employee speech does not interfere with the employee's rights under the NLRA, particularly their right to engage in protected concerted activity, discussing their terms and conditions of employment. So two categories of possible claims here. One would be a Section 7 claim, as I just described. So if the conduct was deemed to be protected or concerted activity, that could give rise to a Section 7 claim, or a disparate application claim. So this is kind of what I was alluding to a minute ago, where the claim would basically allege that the employer did not consistently apply its speech policies to this particular conduct, or that it applied the policies more harshly for union supporters. As we know, depending on your political affiliation, that can be associated with a either pro or anti-union stance. So that's something general to keep in mind here when we're looking at these types of situations. Is a best practice, I would say, to specifically include a disclaimer in any policy that limits or restricts employee speech in the workplace, that the policy is not intended to interfere with employees' Section 7 rights under the NLRA. So also taking into consideration Title VII and New York State human rights laws. Obviously, as we all know, these laws prohibit employment discrimination based upon race, color, sex, religion, national origin, and then a plethora of other categories under the New York law. So, again, as I mentioned earlier, we want to determine whether similar types of speech by similar situated employees have resulted in discipline or termination in the past, and whether discipline or termination in the incident issue could lead to a discrimination claim. So again, for example, if employee A makes some sort of a politically charged comment that seems to be offensive, some employee complains about it. Employee B makes a similar comment, receives such a complaint, but employee B was not disciplined or subject to any other sort of adverse action relating to that could potentially give rise to a discrimination claim or serve as evidence for such. So again, we talked a few minutes ago about including language in any sort of employee policy about not restricting Section 7 rights. We would also want to ensure a facially neutral application of any policy restricting political speech. So what do I mean by facially neutral? That would be prohibiting all political speech, not just speech by one political party or expressing a particular point of view. So in other words, not showing any preference or favoritism one way or the other. Next slide, please. So we also want to keep in mind the prohibitions in place by New York Labor Law Section 201D, which prohibits employers from discriminating against employees for lawful off-duty political and other recreational activities. So the definition of what a political activity would be is either running for political office, pretty obvious with that one, campaigning for a candidate for public office, or participating in fundraising activities for the benefit of a candidate, political party, or political advocacy group. Recreational activities is defined as any lawful leisure time activity for which the employee doesn't receive compensation and is generally engaged for recreational purposes, not including but not limited to sports, games, hobbies, exercise. And obviously here, if you participation in any sort of political functions or speech. And generally, as a best practice, employers should consider, what constitutes off-duty versus on-duty conduct for their specific work environment. One big thing here, especially in the political speech realm, to keep in mind, and that can, maybe blur the lines a little bit, is social media, right? So as we all know, workplace harassment can occur off the employer premises, and not during working hours. Employees certainly, and everyone certainly has the right to express their political and other views on social media platforms, obviously during non-working hours for our purposes here. But it's important to keep in mind that that interplay, and remember that harassment can occur off duty and off working hours. So say, for example, two employees get into a spat on Facebook over, over their political views and political preference, and then that bleeds over into the workplace. That very well could be a scenario which could, where some off-duty conduct does lead over to actionable workplace conduct. Next slide, please. So lastly, just some general considerations, and a lot of these seem relatively straightforward, but probably not a bad idea to be, just express with employees and serve as a general reminder of their general obligation to maintain civility in the workplace and to respect their coworkers, regardless of their political views. Obviously, as an employer, it's up to you as to decide any sort of policies that you want to put in place or may currently have in place on this topic. But as a general reminder to employees, if we are going to be engaged in these types of discussions, just keep it friendly, keep it civil. I think we can all agree that there's enough divide and discord right now in the political sphere that we don't need that hostility bleeding over into the workplace. Reminding employees of applicable non-harassment policies, which certainly could come into play here, depending on the nature, frequency of one employee's political communications to another, and the type, manner, means, and frequency that happens could possibly constitute workplace harassment. Reminding employees of proper channels to report any such conduct that they might find inappropriate or harassing. And again, if we are going to be implementing any policies restricting speech, political or otherwise, in the workplace, ensuring that they are drafted and applied neutrally.
Great. Thanks, Travis. A little slow on my unmuting there for a second, so apologize for that. Very helpful, very timely, appreciate it. Had a question in the chat about public sector employers. I'm not going to put you on the spot for that, Travis, but as I noted to that attendee, that's a great idea for another week. So I will make a note of that to address, what happens when the workplace is actually part of the government. Yeah, I know we have all of our attendees, but it's an interesting contrast, right? Or maybe not a contrast, but a comparison. So anyway, thanks again, Travis, for your time. And I think we do have a couple questions there, but I think if you want to take a look at those, Travis, that'd be great.
Yeah, absolutely.
So Laura, you're up next talking about DEI. Thanks for being here.
Great. Good afternoon, everyone. As Kristen mentioned at the outset, no one will forget that a year ago, it was June of 2023, the U.S. Supreme Court issued a landmark decision that concerns colleges and universities, so higher education, and their admission criteria and admission practices. It had been the case prior to that landmark decision in SFFA that colleges and universities could use race as a bit of a plus factor, one of the factors in deciding whether or not a student would be admitted. And the U.S. Supreme Court issued a ruling that supposedly clarified that previous line of authority to say that is not permissible, that is race discrimination. Race discrimination is race discrimination, said the U.S. Supreme Court, and if decisions are being made based on race, those are impermissible and illegal under a separate set of statutes, not statutes that really apply to the workplace or to businesses per se. But although the decision itself did not apply directly to the workplace and to employers, it doesn't mean that many of the principles being articulated there aren't ones that businesses and employers really need to pay attention to. So under Title VII, under our New York State human rights law, there is an extremely small exception that would allow hiring decisions, promotion decisions, and the like, to be made based on race, to use race as a plus factor, to take race, the race of an applicant or the race of an employee, into account in deciding employment decisions, including positive employment decisions. Who should we hire? Should we hire the candidate that presents us with some diversity and make the decision on that basis? That is an extremely limited exception that requires intense analysis to determine whether or not your business would be able to take advantage of that exception. For the vast majority of employers and businesses, the rule is going to apply. That is, the best qualified candidate needs to be hired in a straight employment decision, really regardless of race. So as Kristen said, when the SFFA decision came out a year ago, it isn't so much that it changed the law for us in the ordinary business world, it's that it placed an increased focus, societal focus on this issue. It called into question practices that maybe certain businesses had been engaged in with the aim and with the intent of doing something positive, increasing diversity, and calling into question how many of those practices would still be viable today in the wake of a changing Supreme Court and a case law around this issue. So immediately after the SFFA decision, there were a number of conservative associations and groups that were poised to start to bring lawsuits to make this point, that just as the SFFA practices were unlawful with respect to race, so were additional practices in the workplace also unlawful. Those decisions are starting to make their way through the courts. Again, the wheels of justice turn very, very slowly, and many of those are still in the pipeline. There was a decision from the Fourth Circuit involving a health system that was issued a couple of months ago, came from the Fourth Circuit, if I didn't mention, it's a little lower down in the U.S. map. It covers North Carolina, South Carolina, Virginia, and that area. And the case was brought by a white male. He had been in a leadership position for many, many years with the company, with the healthcare employer, with the hospital system. And he was terminated, in his mind, quite out of the blue. He brought a case saying that he believes he was terminated for diversity-related reasons because the health system wanted to increase women and people of color and other minority ethnicities in leadership, and so they were making room by getting rid of him. The jury ended up finding in his favor, and there were a couple of noteworthy facts out of that case. So what was some of the evidence that was relied on? There was a quote unquote widespread D&I, diversity and inclusion initiative, to ensure that the health system's workforce and leadership would, quote, reflect the communities it served. And specific practices that were committed to were additional dimensions of diversity in the executive and senior leadership teams, quote, incorporating a system-wide decision-making process that includes diversity and inclusion as a lens, identifying and closing any remaining diversity gaps. There was a financial incentive plan that tied executive bonuses to increasing diversity and increasing, in particular, the representation of certain ethnicities in the workplace. The evidence also showed that there had been a widespread increase in minorities holding leadership positions after this white male had been fired. And the jury in that court awarded $4 million in compensatory damages, as well as $10 million in punitive damages, although the punitive damages were thrown out. So we were left with, nevertheless, a very significant judgment. And just one such example of cases, again, as they're making their way through the courts. And all cases, of course, are dependent on the evidence, right? What is the evidence of the situation? But for employers looking at wanting to do the right thing, that many would say they want to do, they would share some of the goals that I just read for you. Increasing diversity, increasing the idea that a public-facing, public-serving institution is reflective of the larger public. What can a business who is interested in pursuing those goals do? Well, it's always permissible to increase the diversity of your applicant pool. So think about where you advertise for positions. If there are media outlets that you might turn to, whether it's magazines that are targeted towards certain population, it's fine to make sure that your ads are being seen by a very diverse group of people. Much of what diversity and inclusion comes down to is, frankly, what it is, what is said. Are we communicating a message that says that we are an open environment? We want open opportunity, equal opportunity. We want the best candidates, no matter what they look like, no matter whether or not they appear to be physically abled or disabled. We have that kind of attitude that our next best, greatest thing could come in a very different looking package than what we're expecting, but we have no preconceived notions. Those messages are fine. The messages that get us in trouble in DEI initiatives are those that seem that we are looking to achieve a specific outcome. We are looking for a diverse candidate. We are looking for a woman. We are looking for a person of a specific ethnicity. That's the person we think would be best for this role. Those are the messages that get us in trouble, and that may signal something impermissible, and certainly evidence that someone who was denied the position, denied the promotion, might rely upon. Training, as always, is so critically important. Do hiring managers, hiring committee understand these differences, understand the difference between casting a wide net and having an open mind and wanting to give equal opportunity and those values, versus something that looks like we are going out with a pre-designed plan to hire based on someone's race, to hire based on someone's gender, to hire based on someone's sexual orientation or the ethnicity of their family. Do your supervisors and managers understand those differences and understand where the company has decided it wants to be on that spectrum with respect to its legal risk and other considerations? At the end of the day, these initiatives are not illegal. They are not. It is about how they are constructed. And whenever you have doubt, whenever you have questions, you'll want to reach out, get those initiatives evaluated so that you can ensure that your company is doing the global right thing.
All right, thank you so much, Laura. Always useful information. So that actually wraps things up for today. I know it's only 12:30, but you're all going to get 15 minutes free. We're going to end a little early today. If anybody has any questions, here are the emails for our presenters today, who are very generous with their time, but would be happy to field any questions that any of you might have. So go ahead, email them. I also had someone ask for the link for the breakfast briefing, and I'm not able to put it in the chat here apparently, but you can find it just by going to bsk.com. And if we have a link on the top for events, if you go there, you'll find a link. It's a different sign up link for upstate versus downstate. Just pay attention to that. And if I can figure out a way to put a link in the chat next week, I will do that. I'll try to learn that skill in the next week. So thanks again, everyone, for being here, and we will see you next week. Bye-bye.